Hey, Patty, stick right here for a second. All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. Before we begin, let me remind everyone to maintain strict social distancing. I see that you've done a good job about dispersing throughout the courtroom. If you are in a family group, obviously you can sit together. If you're not, you'll see that we have marked the pews with the orange tape. Feel free to spread out and make use of the entire space. Maintain your social distancing when entering and exiting the courtroom. Give close attention to that when you're in the common areas of the hallway or the stairwells or the restrooms or the elevator. It's important that we do our part in slowing the spread of the pandemic, and make sure that if you come in and out, that you're using the hand sanitizers that are mounted on the wall for your use. If you do not have a mask and you would like one, if you'll let the court staff or the bailiff know, we have those available for you. I'm going to go ahead and call this morning's docket. When I call your name, I want you to say here or present and raise your hand so that I can mark you on the docket, after which then we'll begin calling the cases. Jake Taylor Burton. You forgot the here or the present, but I got you, Mr. Burton. Robert Dale LaPlante. Thank you, sir. Brian Anthony Morris. Brian Anthony Morris. Travis Lee Skinner. Thanks, sir. Richard Randall Springer. Thank you, Mr. Springer. Brandy Michelle Chevalier. I have a note that Ms. Chevalier is to appear on Zoom. Is that correct, Ms.? And I do not see her on Zoom at this time. All right, if that's you, Ms. Chevalier, still trying to connect to audio, I'll come back. Michael David Mason. Thank you. Kevin Lee Wood. Scotty Edward Collins. Vivian Darlene Dean. Justin Lee Devine. Robert Brandon Yates. Daniel Marie Borchardt. Michael David Carrier. Matthew John Kearns. Matthew John Kearns, not present in the courtroom. Colton Murph. Xavier Tayshawn Williams. Joseph Nelson McCabe. Thank you, Mr. McCabe. I see you appearing via Zoom. Tanya Louise Red. John Michael Chadwick.
Here.
We're here.
Thank you, Mr. Ugler. Thank you, Mr. Chadwick. Clifton Nasir Gross. Clifton Gross. Darren Bertrand Knight. Francisco Eduardo Zanella. Francisco Eduardo Zanella.
I spoke to him yesterday. I expect him to be here. Maybe just run a little bit late. I'll check on that.
Oh, man.
Jonathan Lamar Kaufman. Make sure you say here present. I see your hand, all right, Mr. Kaufman? All right, thank you. That helps me. O'Darian Dwayne McCray. Mr. McCray appearing via Zoom today. Mr. Knoll, have you seen Mr. McCray? Okay, is he in custody or just, he thinks it's at 10 o'clock? Okay. We'll see if he, yeah, send him a message. We'll see if he appears at 10. Jamil Mustafa Thompson. Jeffrey Frederick Berman. It's Mr. Berman appearing via Zoom. Thank you, Mr. Berman. I see you. John Michael Carmona. A docket reflects the same, arrested August 13th. Rodolfo Gonzalez. Thank you, sir. Ty Allen Hazelbaker. Denny Thurman Howell. Landon Dwayne Musgrave. Rebecca Elizabeth Lowry. Blake Austin Ekrit. Anthony Marcel Hines. There's Mr. Hines. Thank you. Thank you, Mr. White. All right, I believe that's all I have on my morning docket. Is there anyone in the courtroom whose name I have not called? All right, very well. All right, and it appears that I have several, well, maybe not several now, but we have a few that do not have attorneys. If you do not have an attorney representing you in this matter, and it is your intention to seek a court-appointed attorney, then it's going to be required of you to meet with my indigent criminal defense coordinator here to my left, Ms. Patty Tabraham. If you're going to seek a court-appointed attorney, then you need to exit the courtroom, sit in the hallway, and you'll visit with Ms. Tabraham at the end of the hallway on the left to fill out some paperwork. And if that's your intention, then you need to go ahead and step out and do so at this time. All right, counsel, do we have anyone that is agreed with or has a short request? Yeah, I see Mr. Schmidt. So, okay. So, okay, good. Everyone's raised their hand. That's excellent. Now I get to prioritize and make enemies today, I guess. All right, let's see. Mr. Uger, you laughing at me? I hope so.
I am, and Judge, you can take the attorneys in the courtroom over me. I'm not worried.
Okay, I saw you laughing with me, not at me. Okay. All right, so Mr. Schmidt, if you're ready, I saw you were the first hand that came up. All right, is Mr. Lowry here in person? Oh, Mr. Lowry, I'm sorry. Ms. Lowry, come on up to the podium, please, ma'am. CR 19-237, State versus Rebecca Elizabeth Lowry. My record indicates that we are set for perhaps a status on PTI.
Judge, it's my understanding that Ms. Lowry was discharged from the program. This is her setting. Not enough things to discuss the case with the state. I'm asking for the purposes of doing that CPT result.
Any response from the state?
Judge, we cannot hear Mr. Schmidt at all.
Okay, let me change my microphone here. Perhaps this will help. All right, speak up, and this is going to be the microphone here for the attorneys that are trying to pick up, so that's fine right there. Go ahead, Mr. Smith.
All right, you want me to repeat everything for you, Ms. Heisel?
Please.
You're in court, you can hear me. Yeah, basically, this is unsuccessful discharge from PTI program. We're requesting more time so that I have an opportunity to talk to the DA's office to see if we can resolve the case.
No, no objection from the state, Your Honor.
Do you have notices and forms out for?
I don't know in my hands.
I believe we have some new ones too. That's fine if you got that one.
All right.
And Mr. Schmidt, is there a certain time period you're looking for on the reset request?
Just 30 days at this point, Judge.
It's gonna be a little less than that.
That's fine.
Court will reset Ms. Lowry then for September 15th at 9 a.m. Status on her, we'll call that docket call. We'll call it docket call.
Got it.
That's all you got, Mr. Schmidt?
That is just.
All right, Mr. Murley, are you ready? I'm sorry, I couldn't hear you, sir. Who are you ready on?
It was for Mr. LaPlante, Barbara LaPlante.
What's the name?
LaPlante, LaPlante. It's an agreed plea recommendation, Judge.
CR 18-121, State of Texas versus Robert Dell LaPlante. State, can you hear me okay since I switched microphones?
Yes, Judge.
If it gets low or muffled, let me know, okay? All right, Mr. LaPlante, raise your right hand, sir, and place you under oath. And Mr. Murleader, if you wouldn't mind, maybe over here so we keep social distancing and over in this area that way. And make sure you appear on screen right there if you don't mind. That way, as long as you can see yourself right there, then that microphone will pick you up and then you can see Mr. LaPlante. All right, Mr. LaPlante, raise your right hand. Mr. LaPlante, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? I do. All right, you may put your hand down. All right, you are Robert Dell LaPlante, is that correct? Yes, sir. Mr. LaPlante, are you a United States citizen? Yes, sir. Do you read, write, and speak English? Yes, sir. Have you ever been diagnosed with any type of mental condition? No, sir. In this case, you're represented by your attorney, Mr. Murleader. Are you pleased with his representation of you? Yes, sir. Do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered? Yes, sir. Is there anything about this plea agreement that you feel you do not understand? No, sir. And Mr. Murleader, do you believe your client to be competent today?
Yes, Your Honor.
All right, it's my understanding that Mr. LaPlante was on community supervision based on his April 12th, 2018 hearing where he pled guilty to the offense of evading arrest or detention with a vehicle, third-degree felony, which the court on that day found that there was sufficient evidence to substantiate his guilt. However, the court deferred a finding of guilt on that day, placed him on 3 years community supervision, and assessed a $1,500 fine. It appears to the court that the state filed a motion to adjudicate and to revoke on November 21st of 2019, and they have alleged 5 separate counts in that motion. Mr. Murleader, have you gone over that motion with your client, Mr. LaPlante?
Yes, Your Honor.
Is it his intention to plead true to each one of the counts alleged?
Every count except for count 1, which is the offense from Wood County, and the state is abandoning that count.
That's correct, Your Honor. We're going to abandon count 1 in the state's motion to adjudicate.
Thank you, Mr. Cox. And Mr. Murderlater, does your client waive the formal reading of the state's motion to adjudicate?
Yes, Your Honor.
All right, and it appears that the plea agreement Mr. LaPlante has reached with the state is that after abandoning count 1 with pleas are true to counts 2, 3, 4, and 5, that the state's recommendation is that he be adjudicated, that his community supervision be revoked, that he be punished on a lesser included attempted evading arrest with detention under section 1244A with a sentence of 309 days in the county jail with credit for time served and the balance of his financial obligations. Is that your understanding of the plea agreement, Mr. Murderlater?
Yes, Your Honor.
Mr. LaPlante, is that your understanding as well?
Yes, sir.
Okay. All right, then, Mr. LaPlante, then I'm going to ask you as to counts 2, 3, 4, and 5, as contained in the state's motion to adjudicate, are those counts true or not true?
True.
And Mr. LaPlante, are you telling me that those counts are true because in fact they are true and for no other reason?
True.
Has anyone threatened you, forced you, or pressured you to plead true to these counts?
Yes, sir.
All right, court will accept Mr. LaPlante's pleas are true to the counts 2, 3, 4, and 5 as contained in the state's motion to adjudicate. Mr. Murderlater, is there any objection to the offer of the defendant's waiver of rights to plea as true as states exhibit A?
No objection, Your Honor.
All right, court hereby admits states exhibit A into evidence and takes judicial notice of Mr. LaPlante's judicial confession. Is there anything further from the state?
No, Your Honor, we rest and close.
Anything further from the defense?
No, Your Honor, we rest.
All right, then based on the evidence before the court will find that Mr. LaPlante has violated the terms and conditions of his community supervision. The court will follow the plea agreement in this case. The court hereby adjudicates the guilt of Robert Dale LaPlante. The court assesses his punishment. The court finds that state has abandoned count 1 of the state's motion to adjudicate. The court finds that the recommendation is that he be punished on a lesser included attempted evading arrest or detention with a vehicle under section 1244A. Court hereby convicts him of that offense and assesses his punishment at 309 days in the Van Zandt County Jail. Court issues credit for time served in that same amount. The court orders him to pay the balance of his financial obligations. Is Mr. LaPlante going to make payments today to discharge his fines and fees and financial obligations, Mr. Murderlater?
No, Your Honor, but we've counseled him on how to set up a payment plan with Ms. Bonnie LaPrade directly after this plea hearing.
All right, and Mr. LaPlante, you understand that though you've resolved your case today with a time served plea, you understand that when you walk out, you still owe money to Van Zandt County.
Yes, sir.
And you understand that your failure to discharge your financial obligations will result in this court issuing a warrant for your arrest.
Yes, sir.
All right, Mr. LaPlante, you hereby remanded to the custody of the Van Zandt County Sheriff so you can carry out the terms and conditions of your sentence. I'm gonna have you step over here to the left to be fingerprinted by the bailiff. After which, I want you to report to Bonnie LaPrade to set up your payment.
Thank you, Your Honor. That's all I have.
Thank you, Mr. Murderlater. Mr. Green, are you ready?
I am, Judge.
You notice I was waiting for you to just about sit down. And then I'll
Appreciate it.
Where are you ready?
I'm ready on Mr. McCabe and Ms. Red.
All right, we're going to call Mr. McCabe's case, CR 18438, State versus Joseph Nelson McCabe. I show that we're set for docket call today, and the record will reflect that Mr. McCabe is appearing via Zoom. Go ahead, Mr. Green.
Judge, at this time, we do not have a resolution of the case. Visited with Mr. Cox yesterday afternoon, and he was, we discussed either going ahead and putting it on the trial docket or potentially resetting it for another 30 days so he and I can talk to see if there was any resolution that we could reach, whatever makes it for that.
But at this point, there's no resolution to the case.
That's correct.
And do you feel optimistic that you can resolve it by plea agreement, Mr. Green?
Judge, I don't know. I think it's worth talking about, but to be able to say one way or the other, I don't know.
Judge, we're going back to the drawing board pretty much, kind of starting over from square one, but I agree in Mr. Green's assessment that at this point, I just don't know, but I think it's worth a shot.
All right, court's going to present Mr. McCabe on the jury selection trial docket. On October 26th at 9 a.m.
You say 26, Judge?
October 26th. I'm setting it at that period because of the current rules from the Texas Supreme Court regarding no jury trials until October 1st.
Yes, sir.
And Your Honor, if Mr. Green and I were to somehow come to an agreement in this case, would the court entertain a plea bargain still at this point?
The court will consider discussing that with the state and counsel for defense. So I would consider it, but I don't want to set for a plea since we're past on today.
Yes, sir.
Understood.
I'm going to get the plea approved before we set it. So, Mr. McCabe, this is the only notice you're going to get from this court. Mr. Green may provide you with a notice of a copy, but you're ordered to be here in Van Zandt County on October 26th at 8:30 a.m. The notices say 9, but I would recommend you just being here. You're not late until you're after 9. But you need to show up about 8:30 down in the basement of the courthouse, where the courthouse staff will be there to assist you with any paperwork. We'll give you further information about your trial. Mr. Green, though, will not be required to be here unless he receives notice from the court that this case is selected for top 10 trial. Any questions, Mr. Green?
No, Your Honor.
Any questions, Mr. McCabe?
No, Judge.
May Mr. McCabe be excused, Your Honor?
Yes, Mr. McCabe, you may be excused.
Yeah.
All right, Mr. Green, are you ready on Ms. Red?
I am, Judge.
CR 15503, State versus Tanya Louise Red. All right, Ms. Red is set for status today. I believe that we also need to take up a matter of the pretrial release drug test that we had some time back. I know that we need to take up, I think the probation department indicated to me that they had sent that off for confirmation, so we'll need to take that up today. Other than that, I believe that we're set probably for copy call. I'm not certain.
Well, it's a motion to revoke or a motion to adjudicate. I visited with Mr. Cox yesterday afternoon and made a proposal as a resolution in Ms. Red's case. Mr. Cox indicated that he needed some time to visit with probation and consider my proposal, and he asked or proposes that it be set out for a couple of weeks so he can do that. Determine if we can resolve it by what I proposed, and I need to provide him a little more information about what's going on with Ms. Red medically and in her employment. And I think you mentioned that September 15th date with someone else. Would that be a date that would work for the court?
Any objection from the state?
No, Your Honor.
All right, court will set this for hearing on our motion to adjudicate on September 15th at 9 a.m. We'll go ahead and provide her with a copy of her notice of appearance.
This would be a status or a contested day or?
Just put, it's not a contested day, so you just put MTA.
Okay. Or other?
I don't have a copy of that form in front of me. So,
Let's do it. We could, and you said 9 a.m.
yes, sir. You just lay it back. Yeah. And then the yellow one's hers. All right, and Mr. Green, Ms. Red's bondsman has filed a surrender principal release of surety. So there's a warrant for her, so she will be taking into custody at this time.
Okay.
I don't hear it.
Judge, can we hold her for a minute? And
No, we're gonna.
No, I understand, but give me a chance before y'all take her
Yeah,
anywhere.
well, we're gonna park her right here.
Okay,
Yeah.
talk to Mr. Cox and maybe the court when the court has a break.
But yeah, we're gonna put her in custody here. Who's only got one case? Mr. Stevens? Come on up. CR 27-7, Blake, Austin, Egret. Am I pronouncing that right, sir? Okay, good. All right, I believe, Mr. Stevens, my docket reflects that Mr. Egret is set for pretrial today, is that correct?
That is correct, Your Honor.
And are there any contested pretrial motions in this case?
Judge, I'm going to ask for one more pretrial setting. My client and I, actually, to be honest with you, met for the first time a while ago. And I've had some issues with the discovery portal, which is probably on my end, not the state's end. So if we could get one more court date, Judge, it would be greatly appreciated.
Any objection about the state?
No, Judge, that's fine.
All right, court will reset this for a hearing on September 15th at 9 a.m. Mr. Egan, once he gets his copy, he gets the yellow copy.
Yes,
Once he
sir.
gets that copy, he's free to go.
All right. May I be excused?
Yes,
Judge?
thank you.
Thank you.
Mr. Egret, I need you to report to the pretrial release department with their request. Mr. Alton, you say you had one?
Yes, sir.
Just one? Who do you have, sir?
Scotty Collins, CR20,
There you are. Scotty Edward Collins. I show Mr. Collins to be set for pretrial.
Yes, Your Honor.
Any contested pretrial motions?
Not at this time. I haven't had a chance to pick up the discovery from the DA's office. I'd ask for another pretrial so we can get that and I can go over it with my client.
Was discovery made available and you just didn't pick it up? Or
I haven't had a chance to request it yet, Your Honor. I'm going to remedy that this morning and make sure I get that well prior to the next pretrial.
Any objection from the state?
No, Your Honor.
All right, court will set Mr. Collins in for an additional pretrial on September 15th, 9 a.m. And if you'll fill out that notice of appearance form.
Will do, Your Honor.
Give him the yellow copy. Once he gets that, then Mr. Collins, I need you to report to the pretrial release department. Do you have that notice?
Yes.
Yeah, go ahead and fill that out so you can leave me the white one, give him the yellow one.
Good. Thanks, sir.
Anyone else with just one case?
Judge, that one case, but I don't know if it's gonna be for the hearing or whatever. It's a motion to revoke from Jamel Thompson.
Is it agreed? Is it an agreement on it?
No, Judge, it's past the expiration of probation period. We had to put on the evidence, inability to pay.
Listen, we're not taking evidence today. Today's not an evidence day. So I'll tell you what, have a seat. I'll call you just a minute.
Okay.
All right, anyone have anything that's agreed? Mr. Manning? Who do you have that's agreed?
Resetting Mr. Knight and Mr. Zanella.
That's by agreement.
We're setting them for trial, so.
CR 19-317, Darian Bertram Knight. All right, Mr. Knight is set for docket call today, Mr. Manning.
That's correct, Judge.
And Mr. Knight telling the court that he's been unable to reach a plea agreement with the state and he's requesting a trial.
That's correct, Judge. We reject the state's offer and request to be set in the first trial setting.
And is that for defense trial or jury trial?
Jury trial.
And Mr. Knight understands that once he passes docket call, that the court may not entertain a plea agreement. Even if the plea offer gets better, the court may not entertain it.
I'm not going to explain that to Mr. Knight.
All right, court will set Mr. Knight for jury selection on October 26th. And Mr. Knight, on that day, you're to appear in person on or before 9 a.m. in the basement of the courthouse. You'll be directed by the court staff at that time. Okay. And Mr. Knight, I need you to report to the pretrial release department. CR 19-294, Francisco Eduardo Zanella. Set the Dr. Collins meeting.
Yes, Judge, and actually, I had an opportunity to speak to Mr. Zanella and another family member this morning, and I have some new information that may be helpful to the prosecutors. I don't know if they'll be willing to extend one more docket call. Otherwise, we're ready to set it for trial.
Dave.
Judge, if there's new information, we wouldn't be opposed to one more docket call setting to try to see if there's any way we could work this one out.
All right, court will set Mr. Zanella then for docket call on September 15th at 9 a.m.
And Judge, we withdraw our motion to withdraw that's previously on file.
Okay, say that again.
We withdraw the motion to withdraw that was previously set for today as well.
Okay, so your motion to withdraw as counsel,
Yes. And what was that? What was that date?
September 15th. that all you have? Ms. Beasley, you ready?
Yes, I need Mr.
Mr. Zanella, I need you to report to pretrial release department before you leave. Ms. Beasley, who are you ready on?
Danielle Borchert.
CR 2072, State versus Daniel Borchardt. All right, Ms. Beasley, I show that y'all today.
That is correct, Your Honor. I received most of the discovery, but not all. After talking with Ms. Heisel yesterday, we realized there's one clip of the DVD that I have not received yet. And so they're in the process of trying to provide that to me. And I'd ask, Your Honor, once this case is reset, if my client, who is from Florida, could appear by Zoom at the next appearance.
Any objection from the state?
No objection from the state on either matter. We did discover yesterday afternoon that we've copied 2 of the videos, but not the 3rd video in this case. We're working on rectifying that as soon as possible.
All right, court will set an additional pretrial on September 15th. Court will grant the defense's request for the defendant to appear via Zoom. And I would just ask Ms. Beasley that you indicate on your notice of setting the discovery issue that you have so that there's a record of it.
September 15th?
September 15th.
Okay. She's already signed the reset sheet, Judge.
Okay, and let me, Ms. Beasley, if you'll just, Ms. Borchardt, you'll just have a seat. If you'll just check with pretrial release for me to make sure they don't need her. Usually they're here before she leaves.
I will, Judge. She's already been talking with them.
Okay, just make sure before. she
Yes, sir.
leaves. And if they say it's okay, then you can go ahead and tell her to leave. Ms. Borchardt, just have a seat. You wait.
Okay.
Wait. Just have a seat right there in that front row.
Whoop, that's mine.
CR 274, Michael Davis Carrier. Show Mr. Carrier's also set for pretrial.
Yes, Your Honor. I've received the discovery on that case. However, I apologize to the court. I have not had an opportunity to show all of that discovery to him so he can make a decision about what to do with this case. So I'd ask for an additional pretrial setting.
Any objection on the state?
No, Your Honor.
And I would ask, Your Honor, if it could be past September 15th.
All right, court will set this for pretrial on September 29th.
Thank you, Your Honor.
That's at 9 a.m.
Yes, Your Honor. May he be excused?
Yes, once he signs the notice of setting, before we get this copy, it's free to go.
Thank you, Your Honor. I had one other possible judge, but I need to speak. Oh, she approved. I had Representative Jake Burton on a previous case, and I believe he has a new case that's on the docket for this morning.
Have you been appointed to represent him? So, whatever.
Yes. Did you need to see him? He just left. He did. Do you need him?
Mr. Nolan?
Did Mr. Kaufman's case?
CR 275, Jonathan Lamar Kaufman.
Judge, Mr. Kaufman has reviewed at least the written discovery. I called this morning. There are some, I don't know actually if they're DVDs or just CDs, but there's some additional recordings that were copied for me this morning that apparently are ready now. I'd like to set this for another pre-trial because I haven't had a chance to review those. I think that's probably going to include victim statement. Wells Point PD was taken in.
Any objection from the state?
No, Your Honor.
All right, court is for pre-trial on September 29th. Noel, if you'll just ensure that that's written on your notice of appearance form, the DVDs that you're meeting.
Is it possible to set that earlier than that, the 15th?
Or earlier than the 15th? I said on the 29th to give you more time to get the DVDs and review it.
I mean, September 15th, if there's a docket then.
There is a document on the 15th, but that only gives you 2 weeks to get the DVDs.
They're ready today.
Okay, yeah, we can set it earlier.
Okay, that'd be fine.
All right, court will set pre-trial then on September 15th, Mr. Kaufman, not the 29th. We're gonna give you a notice of appearance form, have you sign that.
Judge, the other case that I have on there is, and I think he's on there now, at least I got a text indicating that Mr. McCrary was on.
Do you need Mr. Kaufman? You do. So Mr. Kaufman, after you get this form from your attorney and you sign it, you'll get the yellow copy and then you need to report to the pretrial release department.
Judge, is that time 9 o'clock on the 15th?
9 o'clock on the 15th. All right, Mr. Kaufman, you can come on around this way and meet with probation pretrial release department. Court call CR 25-7, State versus O'Darian McCray, and Mr. McCray is hearing via Zoom today. And Mr. McCray, can you see and hear the court okay? Okay, you're muted. If you'll just unmute your device there, you may have to swipe left or right. There you go.
Yes, sir, I hear you.
Okay, good. All right.
Judge, on Mr. McCray's case, I actually have received 2 offers from the state. I just need to get a clarification on which one of those offers we're proceeding on. And they're fairly divergent. Make sure that we're taking care of all issues that may be outstanding. Probably the 15th would be okay on that because I just need clarification on that issue. I think we have all the discovery. And there is a video that Mr. McCray dealing with the DPS stop on I-20 that I've reviewed. I've discussed that with him. He hasn't seen it, so possibly get in earlier. I actually wasn't aware he was going to appear by Zoom today, but he would be able to at least view that video. There was some question, I think, in his mind as to how that stop happened.
You asking the court to set this for a plea bargain on the 15th, or are you asking for a docket call? Or you
probably just a docket call on the 15th. Between now and then, I'm sure that he can have the opportunity, I hope, to review the video and then figure out exactly what the plea offer is and if it encompasses all issues.
And Mr. McCray, where do you live?
I'm sorry, I'm taking this call from work.
No, where do you live?
I live in Shreveport, Louisiana.
Do you believe 2 weeks is enough time to do all that?
I think so.
All right, the court's going to set this for docket call on September 15th, 9 a.m. So Mr. Cray, you'll need to be in court on September 9 a.m. Okay, so that's the only notice that you're gonna get from this court. Mr. Noel may send you a reminder notice, but this is the only one I'm gonna send you, okay?
Yes, sir.
All right, so, September 15th, 9 a.m. You're free to go.
Yes, sir. Thank you.
Is that all you have, Mr. Noel?
It is, Your Honor.
Mr. White, are you ready? Yes, sir. Who'd you like to go with first?
Mr. Hines.
Is he the only one you have?
I got Mr. Pickett, who's on the, I mean, we can take that up after Mr. Hines because he's in Tarrant County.
Oh. CR 19-235, State versus Anthony Hines. Mr. Hines is appearing via Zoom today for the record. Mr. Hines, why don't you go ahead and unmute yourself there, just that way your attorney needs to ask you anything, or if I need to ask you anything. Our record reflects this is set for docket call, Mr. White.
Yes, sir, it is. Assuming that the portal's correct, that I've received everything on discovery from the state. We haven't received an offer, so we're gonna announce ready for trial.
And Mr. Hines understands that passing docket call today could result in the court not entertaining a plea agreement in the future, should one be reached between your client and the state.
He understands that, Your Honor.
You believe that, from your perspective, the defendant has exhausted all of his negotiations?
To be honest, Judge, I think we're probably so far apart right now on what we might want to do on it that unless something changes drastically, that we're probably not going to come to an agreement.
State agree?
Oh, yes, Your Honor. That's, yes. Ms. Heisel just reminded me which case this is, and Mr. White's assessment's correct. We're probably, there's too big of a chasm between us right now that we're probably not going to get anywhere that could lead us to a resolution.
Okay. The court will set Mr. Hines for jury selection on October 26th. And Mr. Hines, on that date, you're ordered to appear in person at the Van Zandt County Courthouse unless the court grants you permission to appear via Zoom, which your attorney would need to contact the court. Otherwise, you're to appear on October 26th in person on before 9 a.m. and report to the basement of the courthouse for further. Okay.
Yes, sir.
All right. So this is to be the only notice that you get from me, Mr. Hines. Mr. White may send you notice, but this will be the only one that the court's going to send to you here in open court. Okay.
Okay.
All right. You're free to go.
All right. Thank you, sir.
All right, Mr. White, you said you had one set later.
Yes, sir. Cody Pickett, which is CR 17-107 and CR 17-410.
My understanding, he's still in the Tarrant County competency restoration.
He's not in competency restoration, Your Honor. And I made Mr. Cox aware of this. I received a letter from Mr. Pickett since he is incarcerated. I had some real concerns about what was contained in the letter, and I can shared some of that with Mr. Cox. I also called his attorney in Tarrant County, Miss Candace Taylor. She had received a letter that was written on or about the same day. It really concerned her as well. She had indicated to me that she intended on filing another motion for a competency exam. I am not sure. I probably talked to her about 10 days ago, I think, Judge. This has been an ongoing situation with Mr. Pickett.
I thought it was my understanding that he was in competency restoration program in Tarrant County.
He was, and they found him competent. They were dealing with a aggravated assault. Ms. Taylor had indicated to me that they thought that they were getting close to a resolution on that. And now she's got some real concerns about doing anything with him after the letters that we received. So
Is he on bail in their county?
no, sir, he's in jail.
He's in jail.
Yes, sir.
All right, then let's set this for pretrial. Is this a motion to adjudicate or revoke?
No, sir. We had originally, we entered a plea on this. We were going to do an open, come to the court on punishment. We had been set for sentencing. And then during the interim, Mr. Pickett got arrested. I'm not, I mean, I guess it doesn't matter what the circumstances were, but shortly, almost right after that, it took him a while to get him in. But apparently he was suffering some mental problems at the time. It took Ms. Taylor a bit of time to get him in. My other understanding is that he has, I believe, something else in Hood County. Well, I have not talked to Ms. Casper on that in some time. However, I did talk to Ms. Taylor. She seemed to indicate to me that they didn't think that situation was going to be too much of an issue. I feel quite confident that Ms. Taylor is taking the necessary steps.
Hang on just a second. Sir, I need you to step back. Who put you over there? Oh, did you put him over there? Okay, I just want to make sure. All right. Okay, okay, all right. Sorry about that, go ahead.
I feel like she is, what she's done with Mr. Pickett on this has been appropriate, Judge. Given some of my interactions with him prior to the incident, and then kind of knowing his history, I think her concerns are well founded.
What's the state's proposal on Mr. Pickett, that we attempt some kind of bench warrant or attempt to do some type of in custody Zoom hearing, if Tarrant County can accommodate us on that? What's your position on the prosecution at this point, state?
Judge, our plan was to leave him in Tarrant County and allow him to wrap up his business there whenever that may be. And then depending on what happens in Tarrant County, make a decision from there, either let ours go and we cut him loose or bench him back here.
Given the severity of this situation, Your Honor, one of the things that Mr. Cox and I touched on, and also I touched on this with Ms. Taylor, is the possibility of the state transferring their prosecution to Tarrant County in order to maybe let them take it into consideration at that time.
And what's he charged with in Tarrant County? You said aggravated assault?
Yes, sir.
So it's second degree?
Yes, sir.
And where are they at in that process?
My understanding is that they had been extended an offer, and that she was still working through a couple of things with them on it, and that she didn't know what Mr. Pickett wanted to do at that time. And then, as I said, he started, the letter he wrote me was quite bizarre. I'll just put it that way.
All right, let's set this for custody status. Set it October 13th. And perhaps we'll entertain whether or not he could appear via Zoom so we can lay our eyes on him. You have a chance to see him.
Yes, sir. As I said, I have not been able to converse with Mr. Pickett for quite some time, because he's this time that he has been in Tarrant County has been rather lengthy.
That's at 1:30. Okay. Thank you, Mr. Wise. Is that all you have?
Yes, sir. Thank you.
Hey, Judge, is Nolan still there? Can you grab him real quick? Can no one hear me?
You can hear you.
Can we go off the record real quick?
Yes.
Okay, and this is,
Are we off the record on that case?
just off the record in general, Judge. This is a housekeeping matter for Thursday's hearing. It's kind of odd having a conference at the bench when we're on Zoom and YouTube. I think what I'm going to do instead of discussing it here this time is just email the two of y'all. If y'all could keep your eyes open for an email coming from me sometime this morning, just about a housekeeping logistical matter for Thursday's hearing.
Thursday's hearing. Williams?
Yes, sir.
Okay, all right.
All right.
Yes, sir. Mr. Gamble, you ready? Yes, sir. Who do you want to take first?
Mr. Lee.
Xavier Williams, you'll come up, please, sir. Mr. Eagle. I've got a couple.
Yes, sir.
I've got a couple of pleas to do, and since you have offered to let all the attorneys here go before you, you need to step away, then I won't call your case until I see you back, if there's things you need to take care of. Did you hear me okay?
No, sir, I didn't. You cut out. I'm not.
All right, sorry about that. I said, since you're appearing Zoom and you offered to allow the court to take care of the attorneys that are here, you need to step away and take care of some business. I will not call your case until I see you again.
All right. Well, it'll take about 30 seconds, Judge, whenever you're ready.
Okay, all right. Well, I'm going to do these couple pleas with Mr. Gimble. And
okay. Great. Thank you.
You're welcome. All right, Mr. Murph. I'm sorry. That's the next one. Mr. Williams, raise your right hand. You are Xavier Tayshawn Williams, is that correct? Yes, sir. And Mr. Williams, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, let me put your hand down. Make sure you speak up loud enough that I can hear you and that my court reporter can hear you, okay? All right, Mr. Williams, are you a United States citizen?
Yes, sir.
And do you read, write, and speak the English language?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
Yes, sir.
In this case, you're represented by your attorney, Mr. Brent Gimble. Are you pleased with his representation of you?
Yes, sir.
Do you feel like you've had sufficient time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
You understand everything that you have reviewed, read, and signed?
Yes, sir.
Mr. Gimble, do you believe Mr. Williams to be competent today?
I believe he is, Your Honor.
And you've explained to him his legal and constitutional rights?
Yes, I have, Your Honor.
And you've also explained to him the advantages and disadvantages of a deferred adjudication. Is that correct?
Yes, Your Honor.
Mr. Williams, you are charged with, well, pursuant to your plea agreement, the range of punishment for a Class B misdemeanor offense of possession of marijuana is confinement in the county jail for a period not to exceed 6 months or 180 days, and or a fine not to exceed $2,000. Do you understand that range of punishment?
Yes, sir.
I see here that the proposed plea agreement is that Mr. Williams will plead guilty to the Class B misdemeanor offense of possession of marijuana. The state's recommending that it's a finding of guilt be deferred on that lesser included charge. That punishment be assessed at 18 months community supervision with a fine of $500. In addition, you have $270 court costs and reimbursement fees of $535. Is that your understanding of the plea agreement, Mr. Gimble?
Yes, it is, Your Honor.
Yours as well, Mr. Williams?
Yes, sir.
All right, Mr. Williamson, let me ask you at this time, how do you plead to Class B misdemeanor offense, possession of marijuana alleged to have occurred on February 3rd, 2020? And Mr. Williams, are you pleading guilty because in fact you are guilty of committing that offense?
Yes, sir.
Has anyone threatened you, forced you, or made you plead guilty?
No, sir.
All right, the court will accept Mr. Williams' plea of guilt. Mr. Gimbel, is there any objection to the admission of States 1, the stipulation of evidence in this case?
No objection.
Court admits States Exhibit 1, takes judicial notice of Mr. Williams' judicial confession. Anything further from the state?
No, Your Honor, we would rest and close.
Anything further from the defense?
Nothing from defense.
All right, Mr. Williams, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. However, the court will follow the plea agreement. The court hereby defers a finding of guilt, places you on community supervision for a period of 18 months, assesses a $500 fine, court costs of $270, and orders you to reimburse Van Zandt County in the amount of $535. And Mr. Gimbel, do you have the conditions of community supervision?
I believe that was provided to Mr. Williams.
I need to get those. Mr. Williams, you've got any conditions of community supervision with your attorney, Mr. Gimbel? You've read over those? You understand them? You know what's required of you? Violate a single one of those and the state files a motion to adjudicate your guilt. If they bring you back before the court, you're not going to get a trial on whether or not you possess marijuana. There's going to be a hearing on whether or not you violated the terms and conditions of your community supervision. You understand, if you don't take those serious, you could be facing a serious confinement in county jail up to 180 days. You understand that?
Yes, sir.
Right. You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they carry out the terms and conditions of your sentence. I'm going to have you step up here to be fingerprinted with my bailiff, after which you'll report to the probation department through this door. Come on up, Mr. Williams. CR 2060 State versus Colton Murph. Let me give this to you. All right, Mr. Murph, please raise your right hand, sir. I'm going to place you on your oath. Mr. Murph, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand up. Mr. Murph, are you a United States citizen?
Yes, sir.
And do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
ADHD.
Are you currently on medication for ADHD? Do you feel like the fact that you're not on medication or ADHD in any way inhibits or prohibits your ability to understand the proceedings against you today? In this case, you're represented by your attorney, Mr. Brent Gamble. Are you pleased with his representation of you? Yes, sir. Like you've had sufficient time to discuss your case with him, have all of your legal questions answered? Yes, sir. Anything about this plea that you do not understand? Yes, sir. Mr. Gamble, do you believe your client to be competent?
I believe he is, Your Honor.
And you have explained to him his legal and constitutional rights?
Yes, I have.
Mr. Murph, you are charged by indictment with the third-degree felony offense of possession of a controlled substance in penalty group 1, greater than or equal to 1 gram but less than 4 grams. It carries a range of punishment of confinement in TDC for not less than 2 years nor more than 10 years, and also carries a fine not to exceed $10,000. Any plea agreement that you negotiate with the state or any sentence handed down by the court would have to fit within that range. Do you understand that? Yes, sir. It appears to me that you want to enter into a plea agreement with the state in which you would plead guilty to that offense, and the state's recommending that you be convicted of that offense, that your sentence be assessed at 10 years confinement in TDC, but that sentence be suspended and you be placed on community supervision for a period of 3 years with a $2,500 fine and $180 restitution. In addition to that, you would also have $860 in reimbursement fees that you owe to Van Zandt County. Is that your understanding of the plea agreement, sir? Yours as well, Mr. Kimball?
It is, Your Honor.
All right, Mr. Murph, then let me ask you, how do you plead to the third-degree felony offense of possession of a controlled substance? And Mr. Murph, are you pleading guilty because in fact you are guilty? Yes, sir. And has anyone threatened you, forced you, or pressured you to plead guilty to that offense? No. Court will accept Mr. Murph's plea of guilt at this time. Mr. Gimbel, is there any objection to the admission of State's Exhibit 1?
No objection, Your Honor.
Court admits State's Exhibit 1, stipulation of evidence, and takes judicial notice of Mr. Murph's judicial confession. Anything further from the state?
No, Your Honor, we rest and close.
Thank you, Ms. Heisel. Anything else from the defense?
Nothing from the defense, Judge.
All right, based on the evidence before the court will find that there is sufficient evidence to convict you of this offense. The court will follow the plea agreement in your case. The court hereby convicts you of the third-degree felony offense of possession of a controlled substance. The court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice Institutional Division. The court suspends that sentence, places you on community supervision for a period of 3 years, assesses a $2,500 fine, orders you to pay $180 restitution. Court also orders you to pay court costs of $290 and $860 in reimbursement fees. All right, Mr. Murph, you've gone over your conditions of community supervision, is that right? Yes, sir. And you know what's expected of you? Yes, sir. And you know what's required of you? Yes, sir. And you know what happens if you violate your community supervision, right? How long would you be looking at up in prison if you violate your community supervision? 10 years. Up to 10 years. It's pretty serious. You ever been to prison? Do you want to start now? Yeah. All right. All right, you're hereby remanded to the custody of the Van Zandt County Community Supervision Corrections Department so they can carry out the terms and conditions of your sentence. I'm gonna have you step forward with my bailiff to be fingerprinted, after which report to probation department through this door. Thank you, sir.
That's all I have. I'd be excused.
Yes, sir. Thank you, Mr. Gilmore. Mr. Gilmore? Yes, I do have a question for you. Is there an additional misdemeanor? I didn't see a 1245.
There was an additional criminal history charge that was being resolved. His insurance company was paying for the damage to the victim, and Ms. Heisel informed me that was resolved.
Was it Ms. Heisel?
Yes, Judge. So we do have an offer to 1245 that, or dismiss that case once the issue of restitution is settled. However, the issue of restitution has not been shown up to us yet. We are waiting to hear back on that. But that is the agreement, is to dismiss that once we receive proof of restitution being paid.
Is it a follow-up?
It's unindicted currently.
So you plan on rejecting it if the insurance company handles the restitution?
Correct, Your Honor.
To the insurance company or anyone else?
But just so long as the victim is made whole, we do not plan on pursuing prosecution on that particular charge.
So what I'm going to do at this time, so that let's say that breaks down and they end up indicting, and then you resolve the case later, they could be entitled to more money. So to preclude you from that, I'm not going to pay you for that at this time. If that's resolved, then you can submit a new bill.
Okay.
And then we'll pay it.
That's fine.
Once it's actually resolved. I just know I didn't see it. I just didn't see it in the 1245. Or I didn't see the 1245 in.
I understand you.
So if they reject it, then you can submit that and you can do it 1245 or under the agreement. Do the 1245. All right.
Thank you, Judge.
All right, Mr. Hugler. Appreciate your patience, sir.
Oh, not a problem at all, Judge. Thank you.
All right, this is CR 1953, State versus John Michael Chadwick. I believe that, I think my docket says status of DNA, but I think we've gotten past that, haven't we?
I believe so. We've gotten all the DNA results that I'm anticipating, unless Mr. Cox or Ms. Heisel know anything different.
Well, let me do this. Mr. Chadwick, will you take your hat off for me, sir? Thank you, sir. Go ahead, State.
What was that, Judge?
I was discussing with Mr. Hugler regarding the status of DNA, and I asked if I felt like we had gotten past that, and then Mr. Hugler, just go ahead and make your announcement again so the state can hear.
Judge, we have received the DNA, the reports we were expecting from the Garland DPS lab, along with their supplemental documents. I'm not aware of anything else that is outstanding.
Okay. So are we ready to move to docket calls? Or do you need
Judge, the state has made an offer to my client. My client has turned that down. So we'll need a trial setting at some point in the future.
I don't think we've gotten past docket call though, have we? Do you think you would?
No. So if you want to set up for a docket call, that would be fine, Judge.
I just want to make sure that we exhaust all possible agreements here rather than just rush to trial.
Okay.
Try to do that on the front end and on the back end. So that you can advise your client, the court's position, that if there is no agreement by the time we get past docket call or through docket call, then the court may not entertain that. So let me set this for a docket call now that we have our DNA and everything resolved and there's a complete picture of the case. And I'd feel better about there being an announcement to the court regarding plea negotiations once he's had time to consider all of that. So let's, Mr. Yuga, are you available on September 15th or September 29th?
One moment, Your Honor.
Friends cases.
Judge, unfortunately, on both of those mornings, I've got prior settings already.
About the 17th, September 17th.
September 17th, that'll work.
Okay, and we'll set Mr. Chadwick for docket call for 17th.
He was there.
Sorry, hang on. Okay. All right, thank you, Mr. Chadwick. All right, so the court has set you for docket call on September 17th, and I'm going to order you to appear on that date, okay?
Yes, sir.
All right, this will be the only notice you get from the court, September 17th at 9 a.m. All right, thank you, Mr. Andrew. That'll be all in this hearing.
I'm good to leave.
Thank you.
Yes, you're free to go, Mr. Chadwick.
Yes.
Thank you. Have a wonderful day.
You too. Is that all you have, Mr. Huber? We already did one. Hang on just a moment. You've already had one bite at the apple. If I give you another one, there may be a revolt up in here. Unless all of your esteemed counsel here usher you forward. I don't see them saying anything, so I'm not gonna put them on the spot. More than I already have. All right, give me a second. Let me take a counting here. All right, Mr. Sanders, where's Mr. Sanders? Are you still working?
Yes, I've got about, I think, 3 that I can go ahead and do.
No, go ahead. I'll get all your. This taking, did I miss a Zoom hearing that was scheduled at a certain time? Okay, so I was afraid that it was at 10. All right, Mr. Robertson. No, I didn't hardly recognize you with your SMU mask. It took me a second. Good to see you, sir. How are you?
I'm doing fine, Judge.
All right, this is CR 10176, State versus Jamil Thompson. And Mr. Thompson, come on up, sir, to the podium. All right, and based on the brief announcement that I heard from you before, there's no agreement on this case, and you're looking for a setting where you can put on evidence and make an argument?
I guess so, Judge. This is a situation, Judge. He's placed on probation August 5th of 2010. 5 years confinement probation for 5 years. Their probation was extended for 5 years to August 4th of 2020. Their probation has expired. However, the warrant and the motion to revoke was filed on August 4th of 2020. And it's a situation just we're talking about money and some other things, and also he had a stroke, he's had a heart attack, and I.
Well, let's do this before we get into evidentiary issues. Have you spoken with the state about this and y'all tried to reach an agreement?
Yeah, what kind of agreement research? I mean, probation.
Oh, I don't.
I mean, I'm just saying it can't be extended or anything, you know?
No, but as a former DA, I know there's all kinds of agreements that can be reached, but.
Well, I can talk with him, but I just knew that it could not be extended to probation, you know?
Okay.
I can talk with him.
Well, let's do this then. Really, the only thing that I can do is set you for a contested hearing, and I can do that. That's pretty easy. I'll set you for a contested hearing on the state's motion to revoke or adjudicate. We'll set that on October 1st.
That'll be fine, you know?
October 1st at 9 a.m. and then we can take up evidentiary issues on that day. That day is reserved for evidentiary cases, unlike our docket calls and our bigger dockets today, where if I took testimony, we would never get through. So it'll be a much smaller docket that day, and I'll listen to your evidence and your legal arguments on that day. The court will issue a ruling most likely that day.
Yes, on August 1st.
Yeah, October 1st. If you'll get a notice of setting out of there, Mr. Robertson.
Oh, yes, sir.
And then go ahead and fill that out with his cause number, and then put that date on there, October 1st at 9 a.m.
Yes, sir.
And then leave me the white one, and he gets the yellow.
Yes, sir.
Sir. All right, Mr. Gimbel, do you have something quick?
Just a housekeeping matter on the Colton Murphy case.
Yes.
CR 20-00060. His family did provide me a letter to show proof to you and the state that the damage to the victim in the criminal mischief matter has been resolved.
Okay, good. Yeah, submit that to the state. And
Okay.
the state will forward that over.
And I can
They
submit that.
they can give you a rejection letter.
Okay.
That's usually what the state does. They'll give you a rejection letter on that. And, or I'm sure Ms. Heisel will be willing to give you an email or whatever to show that the case has been rejected. And then, yeah, and then just submit that with a new bill for the $75.
Okay. Thank you, Your Honor.
All right. Mr. Green, okay, are you still waiting?
So, Mr. Cox and I are communicating, trying to see if there's some resolution.
We're down to rock, paper, scissors territory here. What's disappointing is I like all four.
I go ahead and do a few minutes.
I think we're gonna take a recess. Might come back to see who's in here.
I think I should have Mr. Berman on, so he can go ahead and get his taken care of. Okay,
All right,
so
let's do Mr. Berman. CR 27-3, State versus Jeffrey Berman. Mr. Berman, for the record, is appearing online via Zoom. We're set for pretrial today, Mr. Sanders.
Yes, sir, that's correct. And we have all the discovery, Judge. There are no pretrial issues. We just asked for a docket call setting.
Can I set you on September 15th? Do you have any scheduling issues?
No, I don't believe so. Have you gone?
Court will set Mr. Berman for docket call on September 15th. Mr. Berman, you're to order to appear on September 15th here in the courtroom with your attorney, Mr. Sanders, and this will be the only notice that you get from the court here in open court, okay? All right, he's acknowledged on the record by head nod that he understands that. So, Mr. Berman, you're free to go. Thanks, sir.
And then, Judge, I have three others too. I can go ahead.
CR 24-3, State versus John Carmona. And I believe that you announced earlier that Mr. Carmona is in the Dallas County Jail. Is that correct?
That's correct. Yes.
We'll confirm that. Let's go ahead and set him for pretrial and custody status on 9/29. Okay. No, I'm sorry. Let's do 9/15 also. Let's keep you on that same day. So the court has set that September 15th, 9 a.m. for pretrial and custody status. Are you lacking any of the discovery or anything in that case?
No, Your Honor, with him, I think we have everything.
CR 17-196, Rodolfo Gonzalez. Mr. Gonzalez. Don't forget, Mr. Sanders, I need Mr. Gonzalez to report to pretrial release at the conclusion of our hearing. And also, I'm gonna need a TRN order. I don't know if anyone, usually the state provides that. State, I don't know, Ms. Abney, if you're still joined with us on Zoom, I'm gonna need a TRN order for Mr. Gonzalez to be able to go book in and book out and get a tracking number for DPS purposes. So I don't want to forget that. Mr. Gonzalez is set for pretrial today as well, Mr. Sanders.
Yes, Your Honor. Judge, we have the discovery and offer, and we don't have any pretrial issues at this time. We'd have to be set for docket call. I think there is one. I think the state does have one DVD, but there aren't going to be any kind of pretrial issues with that. So we just need to get that.
Do you believe September 15th is sufficient time?
Yes, I think that'd be fine.
All right, court sets Mr. Gonzalez for docket call on September 15th. Once you get that form, your appearance form, sign that for Mr. Sanders, and then report to the pretrial release department. And then once you meet with the pretrial release department, then I want you to come out here and sit back down so that I can get an order for you. And then Mr. Gonzalez, when I give you this order, I'm going to direct you to go to the Van Zandt County Justice Center, to the jail. You'll present that to them. They will bring you in and they will book you in, book you out. Shouldn't be a change out or anything like that. Just you have to go in there and we got to get your fingerprints so that we can report them here within this county, okay? So after you meet with them and get information from them and have a seat, I'll get that order signed and then we'll get you on your way. All right. Ms. Heisel, Mr. Cox, can someone confirm with Ms. Adams whether or not she provides that TRN order, or if the clerks have it? I'm not sure. Usually it doesn't appear on my desk.
Judge, I believe that we provide it. I have made a note to have one prepared for that docket call on September 15th so that we can get that issued through that day.
Well, we were going to do it today, though.
Oh, today. Let me go ask her if we can get it sent over to the court.
And it should just be a form document, and then if you can just email it to one of the clerks, to my coordinator, and we'll print it off, and he's got to meet with the pre-trial release department, if you don't mind.
Sure.
You ready on Hazelbaker?
Yes.
CR 19-141, Ty Hazelbaker. I believe we're set today for a motion to revoke.
Yeah, that's correct, Your Honor, and I was just appointed this morning. I need to get a copy of the motion to revoke your application to proceed, and I would ask if we could reset it 30 days, or even September 15th would be fine.
I can give you September 29th if you want more time.
Yeah, that might be good. I know I'm already going to be here on the 29th anyway, so that'd be fine.
All right, then the court's going to grant Mr. Sanders' request for additional time to prepare based on his recent appointment to the case. The court will set this for motion to revoke on September 29th. That will not be a contested hearing date, Mr. Sanders. Mr. Hazelbaker, once you sign your notice of appearance, do you need to see him at all? Remember, Mr. Hazelbaker, you're still on probation. Still required to report. You're still under the orders and authority of the court, okay? So just because a motion is pending doesn't mean you don't have to report, you don't have to take drug tests, you don't have to pay. That does not mean that.
Yes, sir. I got an appointment 15.
Good. All right. Once you sign that notice of setting, then you're free to go. Then Mr. Sanders, make sure that I get the white copy, they get the yellow copy. You ready on Mr. Howell?
No, not yet, Judge. Mr. Musgrave.
CR 28-7, Landon Musgrave. Mr. Musgrave set for pretrial.
Yes, Your Honor. Judge, we have the discovery and offer that we don't have any pretrial issues. We just ask that it be set for a docket call.
15th or 29th?
Let's go 29.
Court sets Mr. Musgrave for docket call on September 29th at 9 a.m. Mr. Musgrave, once you sign the notice of appearance and receive the yellow copy, I need you to report to the pretrial release department. And then once you get information from them, you're free to go. Ms. Beasley, this is it on Mr. Burton.
Yes.
Mr. Burton, CR 2108, State versus J. Taylor Burton. Mr. Burton set for arraignment today?
Yes, sir.
And you've been provided a copy of the indictment? is that
Yes, sir.
correct? And have you gone over that with Mr. Burton?
I have.
Does he waive the formal requirements of arraignment?
He does, Your Honor. He understands the range of punishment, the nature of the charge, and wishes to enter a plea of not guilty this time.
And I believe you said his name was spelled correctly. Is that right?
That is correct, Judge.
All right, the court will enter Mr. Burton's plea of not guilty into the record. Court will set this for pretrial.
Judge, if I could, he has another older case in this county that's set for the 21st. I'd ask that be removed from the 21st docket and placed along with this case so we can resolve both cases. Ms. Heisel and I are in communication, and we're hopes that in a couple of months, we might be able to resolve both of them.
He said on 21st of
September.
for jury selection. So you want to take it off the jury selection?
Correct, so we can resolve both cases. We believe this may result in a plea on both of them.
That would result in him losing his trial placement, so that if it doesn't work out, he would go back to the bottom of the list.
Judge, we're pretty sure we're gonna get everything resolved.
Steve, what's your position on that? Because you would also, I mean, it would take Mr. Burton out of his current placement.
Judge, the new charge is not factually related, but it's similar in nature. We do believe that the new charge is going to help resolve the old one. So I believe at this point, Ms. Beasley and I's conversations have been extremely fruitful. I do believe there is a resolution in sight, so I would not object to taking it off the trial docket.
And if I may, he also has a case in Kaufman County that we're also believing that that's gonna be resolved as well.
I'm hesitant to do that, but I would tell you what I would entertain that would resolve my hesitancy. If Mr. Burton waived his right to a jury trial in that case, then I wouldn't mind putting him back on. But once he's passed docket call, he's in there, then I don't want to take it back off the jury trial docket. But if he waived his right to a jury trial, then that would put me in a position where we could sit him for a bench trial if negotiations fail.
Your Honor, could you have a request of the DA, maybe email one over here to give you a chance to talk to him about that?
Well,
Maybe recall this in a few minutes.
We can do that, or I can go ahead and set him today, and we can take up the waiver of jury trial. He would have to appear, if we set it September 15th, we set the pre-trial. I don't know if that's real quick for you, isn't it?
Real quick, Judge.
But we do this. How about we set it September 15th, and Mr. Burton can appear via Zoom for the waiver of jury trial, so that has to be an open court. You can appear via Zoom if you're not already going to be here, Ms. Beasley. So if you're not going to be here on the 15th.
Oh, Judge, I have several cases already set for.
So Mr. Burton can come on the 15th, and we can waive his right to jury trial, and that will prevent him from having to come on the 21st. And then on the 15th, we'll set that on the same day that we're going to set this one for pre-trial. So we'll set this one for pre-trial on
September 15th, Your Honor?
No, we'll set this for pre-trial on September 29th. Today's case, CR 2108. And then once you get the waiver of jury trial, then we can set that on September 15th. And once that waiver of jury trial is signed, accepted by the court, then we can move that case to the 29th, and then you'll be together. So for today's purposes, Mr. Burton, you're set for pre-trial on September 29th at 9 a.m. And Ms. Beasley will get with you regarding the scheduling of waiver of jury trial, if that's what you'll like to do. If that's not what you'll like to do, then you'll be here on the 21st. Jury trial selection reset, because there is no jury trial in September for Supreme Court order.
So we'll do a pre-trial.
Well, we'll do pre-trial on the 29th, and then Ms. Beasley will talk to you about your options for getting off that jury selection.
pretrial, release conditions.
Ms. Wood, do you need Mr. Burton?
I gave him paperwork.
All right, once you meet with pretrial release, then you're free to go. Mr. Adams, you ready?
Sure, Your Honor.
Who are you ready on?
All three. Chevalier, Mason, and Wood.
CR 18467, Brandy Chevalier. And I believe Ms. Chevalier is appearing Zoom. I've acknowledged her presence on Zoom for the record, and I believe that Ms. Chevalier is set for pre-trial today, Mr. Adams. Mr. Adams, if you don't mind, you'll just move to your right a little bit, that way she can see it. There you go.
Okay.
All right, go ahead.
Good morning, Ms. Chevalier. Your Honor, I think we are still missing some video footage. This is an alleged theft from a Walmart. In my experience, there's always video footage from the Walmart, and I'd ask if the state would mind double checking on that for me. Once that's confirmed or denied, then that'll resolve our discovery issues. We still don't have a plea offer from the state.
Okay. State, any information on the Walmart surveillance footage that Mr. Adams has referenced?
Judge, I do not have that information at this time, but if we could get another pretrial, I'll get both of those issues resolved for Mr. Adams by the next pretrial date.
Well, he'll need them before, he'll need them at least probably 10 days before pretrial, because he's required by the code to file this pretrial motion 7 days before that. So what I'll do is I'm gonna set it out a little further for you, Ms. Heisel. I'm gonna set it out on September 29th, unless you have any scheduling issues that day.
If it's in the morning, I think I do. I have some prior settings in another county. Let me double check, make sure.
Forgot to go over that with council.
Your Honor, on the 29th, I do have two other settings in a county court at law in Smith County. I think I'm here.
Would you like to appear Zoom that day? It's for purposes of pretrial. You
I
want
can
to
do
appear
that.
via Zoom that way, and then you can just, whenever you get through with court that morning.
Sure.
Maybe a little bit later, but any time between 9 and 12.
Sure, that'd be fine. And my other two hearings may very well be by Zoom. I haven't been notified yet, but
okay,
that would be fine. Yes, sir.
Okay. All right. Well, with Ms. Chevalier appearing via Zoom today, the court will bring her to appear by Zoom on September 29th at. We'll just have you appear at 9 a.m., Ms. Chevalier, and Mr. Adams may be a little bit delayed on that, handling these other court matters in the other county. And Mr. Adams, if you will, do notice the setting form. You notice there that there's a box there for items needed, issues like that. If you wouldn't mind making sure that that's recorded on that notice of setting.
It's filled in.
Yeah, good. And the white one stays with me. And then, yes, you'll retain the yellow one. Ms. Chevalier, you will not receive any written notice or mailed reminders about the hearing on the 29th. I'm going to allow you to appear via Zoom that day at 9 a.m. Okay, September 29th.
Yes, sir.
Okay.
I'll remind Ms. Chevalier between now and then. We'll have some phone conversations.
Ms. Adams, okay?
Yes, sir.
Okay, excellent. All right, you're free to go, Ms. Chevalier.
Okay, thank you.
Michael Mason. CR 2055. My record reflects that we are set for docket call today. Is that right?
That's right, Your Honor. I tend to think, I don't have video footage, and I tend to think that there may be some. This is a traffic stop on Interstate 20.
It was in camp, you talk about that.
Yeah. So I'd ask the state if they wouldn't mind. I hate to sound like a broken record, but if they could double check on the existence, if any.
We're talking about a dash cam footage?
Yes.
We're talking about surveillance?
Dash cam.
Dash cam. State, do we know if there's dash cam video available in this case?
I'm gonna check right now, Judge, if I could have 30 seconds.
Yes, sir, please do.
We have a plea offer from the state. It's been declined. I don't think that we're going to reach a meeting of the minds on that issue. Mr. Mason does have a co-defendant, his son, who I understand is going to enter a guilty plea in exchange for a plea offer. I don't know if it's necessary that take place before Mr. Mason's trial, case is tried before a jury or not. I guess that would be up to the court. But we're, aside from the issue of, or the question of video footage, we're otherwise ready to go.
We don't have anything in Mr. Adams's box for this case.
Right, but no, I think his inquiry was whether or not dash cam footage exists.
Let me see.
Is that correct?
Correct. It occurs to me that I can check with Deborah Beasley. She represents Mr. Mason's co-defendant. If she has any dash cam footage or can tell me whether or not, because the evidence would be the same in both cases.
Judge, there's 1 CD and 8 DVDs.
Do you have any DVDs, Mr. Adams?
I don't believe that I do.
Don't believe you have any video?
I don't think that I do.
So this is what we'll do is based on your announcement, the court's going to set Mr. Mason then for jury selection, and obviously he's not going to be reached for trial. But we'll begin the jury selection process, the setting of that on October 26th. Mr. Mason should report here before 9 a.m. in the basement of the courthouse. There you'll be met by courthouse staff to give you further instructions. And Mr. Adams, as you are acquiring the DVD footage from the state, should an issue arise to cause you to need any type of contested pretrial motions, motion to suppress, anything of that nature, then I'll grant you leave to file a motion to suppress, and then we can take that up while he is still pending jury trial.
Understood, Your Honor. And I'll make sure to be efficient, my time efficiently between now and then as soon as I get the DVD.
Mr. Gonzalez, okay. I want you to go, you can exit out this way and follow Ms. Abraham here, and she'll get you situated, okay? All right. Mr. Mason, once you sign your forms right there and you receive your notice of appearance, you're free to go. Once you sign your notice of appearance and you've dealt with the pretrial release department, then you're free to go. Well, you'll sign the white paper and then we'll get the yellow copy. No, you don't get the white paper. I get the white paper.
I'll sign the yellow paper.
Well, when you sign the white, it should have gone on to the yellow automatically. Carbon copy. You ready on Mr. Wood?
Yes, Your Honor.
CR 29-6, State versus Kevin Wood. Mr. Wood is set for pre-trial today.
That's right, Your Honor. Our discovery is complete. There's nothing that we're missing. We have a plea offer from the state. Mr. Wood advised me yesterday that he intends to accept that offer. We don't have the paperwork prepared here today. So what we would like to do is reset this Mr. Wood's case for a plea and sentencing hearing.
Why have you coming back on in September?
September the 15th, I think.
15th?
I'm already on that document.
Okay, you're already on that docket, then we'll set Mr. Wood then for plea on September 15th.
Okay, Your Honor.
Is that all you have, Mr. Chairman?
For this morning, yes, I'm on the afternoon docket too. So I'll see you back down the street.
Down the street. Mr. Ashmore, you ready, sir?
I am, Your Honor.
Who do you want to go on first?
Probably Mr. Devine, if that's all right, Your Honor. Sure.
Mr. Devine?
Well, let me, just housekeeping. Told me that his roommate, which I believe is his girlfriend's husband, may be positive for COVID. I told him to stay outside.
He's outside the hall?
Yeah, yeah. And he's been here all morning, but I just said, we don't want you in the courtroom. He can't get tested till Friday. He doesn't think he has it. The roommate may not have it, but I was just like, we still need you in the courtroom. So I'm just gonna ask the board for a reset. And if he needs to be told when that is, we'll figure out how to do that. The state just recently produced us discovery. It is a lot of, I think it's like 12 DVDs, Judge, and frankly, we had some trouble uploading it to our system. I just haven't had time to go through it. We don't have an offer yet. I think we're working in that direction. I'm just gonna ask for a next setting so we can get a plea offer and digest the discovery and talk to him about it. If that's acceptable.
I'm sorry, Judge, didn't get that.
Any objection by the state on the request to reset pretrial? Mr. Ashmore has indicated that he's still going through the discovery.
Yes, Your Honor, the discovery is very extensive in this case, so I think that that's appropriate. In fact, we wouldn't be opposed to setting it out like 45 days if he needed that. Mr. Ashmore and I have discussed some different options for resolutions, although a formal offer hasn't been made. So we're good with setting it out a little bit longer for him.
How are you on?
That looks great. Thank you very much.
All right, court will set this for pretrial then on October 13th. All right, so Mr. Ashmore Base, I'm gonna need some assistance from you. Have you already been in contact with him this morning?
Yes, he's literally out in the hall. He's wearing a mask.
He's wearing a mask.
So I can have him sign this, we'll throw away the pen and we'll get him out of here.
When you're doing that, I also need him to sign his conditions of pretrial release. I need you to go over those with him. Have him sign those and fill out this form and bring this back to Ms. Wood for the pretrial release department. And after he signs that, he's free to go.
Okay.
Once he gets this, gives it back to you, give him the yellow copy, live one stays with me, and he'll be free to go.
Okay.
Thanks for being vigilant on that COVID issue.
Yeah, it could be nothing, but like I said, he can't be tested till Friday, so I just had to stay outside.
Yeah, as an officer of the court, I'm taking your statement. We're gonna vote that.
Okay, thanks, Judge. Should I handle that real quick, or should we do Mr. Dean and Ms.?
Go ahead and handle that, and let's get him out, and I'll take up some other matters, and when you come back in, I'll put you right back.
Thanks, Judge.
I believe that's everyone that has attorneys. So maybe Mr. Sanders is still working on Mr. Howell, perhaps. Is Brian Anthony Morris here? Brian Anthony Morris. Mr. Springer, CR 18340. Springer, my recollection is that the court has already approved for you to represent yourself. Is that right? I think it's been a while since you've been in here. Is that still your desire to represent yourself? Okay. And I believe that we're set for docket call today. State, you may have to help me out here. I'm not sure if there was ever any discussions between the state and Mr. Springer. I know that may have been before both of your times in your current felony positions here in Van Zandt County, but Mr. Springer, I believe that I recall him being approved to represent himself, and we've already gone through that requirement, through the legal requirements of that. Has there been any discussion between you and the state, Mr. Springer, regarding your case?
No, not recently, no, we have not previously.
State, do you have any notes in your system or any recollection of Mr. Springer's case? I believe that we had a motion to suppress hearing. I believe that we heard and argued that. I believe the state denied the motion to suppress, or perhaps it was filed and we didn't hear it. I'm going to have to go back and review that. But
Judge, I don't show where we've ever spoken with Mr. Springer.
let me take a moment and look in the clerk's file regarding his waiver of counsel so we can make sure we're in compliance with the law.
Excuse me, Robert.
The clerk's record reflects that we had, let me correct that, the court's system reflects that we had a motion to suppress hearing on February 28th, 2019. And I think what complicated this case is that Mr. Springer missed court and there was a judgment, an ISI forfeiture of his bail, and he was rearrested. So here, Mr. Cox, Ms. Heisel, I see that Judge Drum on October 11th, 2018 entertained Mr. Springer's request to waive his right of representation by counsel. And she approved that on that date. So this is what I want to do, Mr. Springer. Are you interested at all in speaking with the attorneys for the state to see if you and the state can come to an agreement regarding your case? You do? Okay. So this is what I'm going to do for you, Mr. Springer. I'm going to reset this until September 15th. That's not a very long reset, it's a couple of weeks. What that's going to do is going to allow you some time to contact the state of Texas, find out what their offer is. Y'all can discuss possible resolutions, and then you can come back on the 15th and let me know what the announcement is on that. So we're going to set this for a docket call on September 15th. Yes, you can contact the assistant DAs by phone. State, is there a preference of how you want to be contacted by Mr. Springer?
Judge, if he calls our office, that'd be fine. Perhaps we could visit with him Friday if he's available.
Perhaps Friday, you can give the DA's office a call and they can discuss the case with you then.
And Judge, if you'll just have him let whoever answers the phone know that we're expecting his call, because typically when defendants call in, they don't forward the calls on to us. They keep them at reception. So just let him know he'll need to tell them we're expecting his call.
All right, you understand that, Mr. Springer? So when you call into the DA's office and the receptionist answers the phone, give them your name, give them your case number, and tell them that you're representing yourself and that you have an appointment to speak with the assistant DA so that they will be expecting your call. And then that way the assistant DAs will receive notice that you're calling and they can take the call, okay? So that my memory doesn't fail me, it's 903-567-4104, correct? Title, Mr. Cox?
Yes, Your Honor.
Pretty sure that number will be seared into my head for a long time, but. And Mr. Springer, what's your current address?
11408.
11408.
Cameron Road, CAMR, Lot D.
As in dog? Lot D, as in David?
That's Maynard, Texas. 78653.
78653.
I have a couple other issues.
Sir?
Speaking to the microphone. I have a couple other issues I want to bring to you.
Well, let's, what are those issues, sir?
File a motion on 15th of this month. And, hearing on the motion.
What's the motion?
Motion to retest the substance.
Well, let's do this. Before I entertain that, I want you to speak with the state, because if you're able to resolve your case without us having to retest the substance, then I want to find that out first. If y'all cannot reach an agreement, then we'll take up your motion on the 15th. Okay. All right, so I'm gonna hand this back to you, and I'm gonna have a note written in there. Contact the DA's office, and I'm gonna write their phone number down for you. All right, Mr. Springer, once you get that, you're free to go, and make sure that you make contact with the prosecutors well in advance of September 15th so that we can have an announcement. If there is no agreement with you and the state, then we'll take up your motion to retest on September 15th.
Thank you, sir.
You're welcome. Mr. Ashmore,
Yes, Judge.
are you ready?
I am, Judge.
All right, who do you want to call next?
Let's call this Dean. It's just a set for jury trial.
Vivian Dean. This is CR 19230. I believe at the last setting, Mr. Ashmore, there was a suggestion of incompetency. And since that date, the court had authorized the evaluation on the basis of competency. And the report that the court received was that Ms. Dean was found to be competent by Dr. Ingram. Is there any challenge to Dr. Ingram's finding at this time?
No, Your Honor.
I'm assuming the state doesn't have a challenge either, is that correct?
No, Judge.
All right, and so at this point, with Ms. Dean having been found competent, there being no challenge to that, has Ms. Dean and the state exhausted all of their negotiations in this case, Mr. Ashmore?
Unfortunately, I think so.
State, you agree?
Yes, I agree.
All right, so Mr. Ashmore, do you believe that Ms. Dean understands that if the court passes her through docket call and sets for jury selection, that if she later changes her mind and decides that she wants to accept a plea agreement, or even if the state wants to offer a lesser charge, that the court may not entertain that at this time?
I have explained that multiple times to Ms. Dean, and including this morning and going back over recently the two plea offers that have been extended by the state of Texas.
What are those?
Both of those are Class A misdemeanor probation type plea bargain agreements. So reducing the second degree felony to a Class A misdemeanor with them. They are onerous, but they are a path to freedom probation conditions that include some incarceration time.
Let's go ahead and just put it on the record exactly what it is. Is it straight? Is it deferred?
There's a straight 12 months Van Zandt County Jail Class A misdemeanor deadly conduct offer that was extended in early June.
Probated?
No.
Okay, just straight time?
No, because Ms. Dean requested a straight time offer. And the state complied with that request and offered to reduce the offense to Class A misdemeanor. And then a second Class A misdemeanor with, I believe it was 14 days county jail time, and then the rest of that sentence would be probated. And I can't remember exactly the duration. It was 12 or 18 months.
Any clarification from the state on that second offer?
I believe it was 12 months, Judge. As Mr. Ashmore recited, I made two different offers on a Class A assault. And I just don't think I can do any better than I already have.
Well, he mentioned the 12-month straight time, but then he's indicated that there was some type of probated offer with 14 days in jail as a condition of probation. Is that what I heard correctly?
I believe, that's my recollection. I will memorialize that in an email to Ms. Dean. I can look for it if.
Let me pull it up, Your Honor. Judge, the offers were there was time on a Class A deadly conduct, and then there was a 1 year probated 12 on a deadly conduct with 10 days in jail as a condition.
One pro 12 with 12 days in jail.
10 days.
10 days in jail. One pro 12 months, 10 days in jail as a condition of probation. And so, Ms. Dean, you are rejecting both of those offers, is that correct?
Yes, sir.
You're not rejecting those?
Yes.
I think there needs to be more communication between you and Mr. Ashmore regarding whether or not you're going to accept one of those.
Well, I think I can speak.
Well, you can speak for yourself, I'm sure, but you can't speak for yourself in here because you requested a court-appointed attorney, and Mr. Ashmore was appointed to you, and he speaks for you. Okay, so what I want to know is, are you going to accept one of those, or are you rejecting both of those? And while you're thinking about it, if in fact you are charged with aggravated assault with a deadly weapon, which appears to be a second-degree felony, the range of punishment, should you be convicted of that offense? That's an if. Should you be, if you are convicted of that offense, the range of punishment that the court or the jury, whoever decides that issue, could put you in prison from anywhere from 2 years to 20 years, and also assess a fine up to $10,000. So what I've heard from both the state and from your attorney is that the offer by the state is to remove the possibility of prison in your future. In exchange, they're asking you to plead guilty to a lesser offense of deadly conduct, and have given you a choice of either accepting a 12-month or 365-day sentence in the county jail, or accepting a conviction for deadly conduct, receiving a 12-month sentence in jail, with that sentence being suspended, you being placed on probation for that 1 year period to comply with terms and conditions of probation. And a part of that, one of the terms would be that you would serve 10 days in jail. And it appears to the court that if you accept either one of those, your case would be resolved. If you accepted the probation, then if you complied with every term and condition of your community supervision, then you would serve 10 days in jail, and then you would serve the rest of it in your home and in the community. So what I want to do is, Mr. Ashmore, is this your last case?
No, I have an arraignment on Mr. Robert Yates.
So this is what we're going to do on Ms. Dean. Ms. Dean, I want you to have a seat. I want you to think about that. And then I'm going to let Mr. Ashmore finalize his last couple of cases. And then I want you and him to talk a little bit more before we announce whether or not we're going to reject it, because this is what's going to happen. And I'm not trying to force you to accept something. I just want to make sure that you are clear as to what will happen if you say, I don't want either one of those. And that is certainly your right to do that. But if you reject those and you can't reach an agreement, I want you to have done that with clarity of mind and being fully informed of all the legal possibilities and consequences, because the court would then give you what you would be asking for, which would be a jury trial. And then a jury of your peers would decide, or the court would decide based on your election. And if convicted, I want you to understand that can certainly be on the table for you in your future. Okay, and I don't want there to be any buyer's remorse that had I known, and a lot of times people do that, they look back and think, wow, I could have this done with 10 days in jail and probation, but now I'm looking at 20 years in prison. I don't know the facts of the case. I don't need to know the facts of the case. Mr. Ashmore has that, the state has that. That's not my business at this time, okay? My business is to make sure that you receive your counsel. And I've done that, and that he's representing you, and that he's explaining to you all of the legal nuances regarding what you're looking at on this charge. Okay, And I want you to have as much information as you can so that you can make an informed decision. And then that's what we do. You tell me what right you want to invoke, right to a plea bargain, right to ask for a bench trial or a jury trial. And I want you to do that after having weighed all of the circumstances and the facts and making a decision that's best for you. Okay? So go ahead and have a seat. Mr. Ashmore will be back there with you in just a moment.
Thank you, Judge.
You ready on Mr. Yates?
I am, Your Honor.
CR 20-97, State versus Robert Yates. Mr. Yates is set for arraignment.
He is, Your Honor, and
Has he had a chance to review the indictment?
we're gonna do it right now, but he does understand the facts and allegations against him. The state was kind enough to email it over to me this morning. We had some problems getting it off the portal, but as I understand it, our office now has it. If you just give me about 10 seconds to review.
Yes, sir.
Judge, while they're going over that, just wanted you to be aware that Miss Abney sent over a blank TRN order to the clerk for them to have that for anybody who might need one.
Okay, thank you. We get to get Mr. Gonzalez out over there, so thank you for that. Ms. Adams, you're still with us. Thank you very much. You ready, Mr. Ashmore?
We are ready, Your Honor.
Okay, does Mr. Yates waive the formal reading of the indictment?
He does, Your Honor.
And he waives the formal requirements of arraignment?
Yes, he does, Your Honor.
His name is spelled correctly?
Yes, it is, Your Honor.
And he understands what he's charged with?
He does, Your Honor.
In his plea at this time?
Not guilty, Your Honor.
Court will enter Mr. Robert Yates' plea of not guilty into the record. We'll set this for pretrial. Set this for pretrial on September 29th, unless you have any scheduling issues, Mr. Ashmore.
No, I think I'm actually here that day already. We appreciate it.
All right, Mr. Yates, once you sign that and you receive the yellow copy, white copy stays with me. After that, I'll need you to report to pretrial release department over here to your left with Ms. Burns here. After that, once you receive information from her, you'll be ready to go.
Judge, may I be excused to talk to Ms. Dean for a moment?
Absolutely, yes, thank you, sir. I see that Mr. Green, y'all still working?
I did have a text communication with Mr. Cox, and I was waiting for that break.
I see that Mr. Files or Mr. Harrison's in the online. Wait a minute, let's see. Good morning, Mr. Files.
Good morning, Your Honor.
How are you today, sir?
I'm doing well, sir.
Great to see you. I do not see you on my docket. Can you tell me the name of your client?
Mr. Hendricks, Mr. Harrison, I think is probably on your docket. Mr. Harrison is in New Mexico, so I'm sitting in for him.
Page 7.
Oh, okay. All right, court call CR 20-81, State versus Jeremy Ryan. Not sure that we're set for pretrial today, Mr. Powell.
Mr. Harrison asked me to announce that the state has furnished him with an offer. He is out of the state. We'll be back on Wednesday, and we'll have the opportunity to discuss it with his client at length then, and ask if this could be carried over to the next docket, and we believe we would have a resolution at that time.
Mr. Files, do you know if Mr. Harrison has any contested pretrial motions?
No, there are no pretrial motions to be filed.
Okay, good. So what the court will do then is the court will set this for docket call on September 15th. Do you know if Mr. Harrison has any scheduling issues on that day?
If you can hold just a moment, my legal assistant is standing outside with our client. If you can let me step out, I'll be able to look at the calendar and be able to tell. Kimberly, 15. Okay, what we got?
I can do later in the morning.
Your Honor, I'm looking at the docket. We have a docket call at 9 a.m. on the 15th. We have a Zoom in the 7th at 1:30. We have a Zoom in the 7th at 2:30. And we're not trying to set the time for the court to call its docket, but he has those. I'm sure I can announce for him if he cannot make it.
Okay, then we'll set this for docket calls. The court will find that there are no contested pretrial motions and sets this for docket call on September 15th at 9 a.m.
Sorry, that's mine.
And Mr. Files, do you know if he'll be appearing via Zoom?
Please, the court, we could not hear the time the court said.
Oh, 9 a.m.
9 a.m.
Yes, sir, on September.
That's all we have before the court.
Mr. Files, sorry, we're having I think you have some tech issues on your end, or maybe our internet got here. Yeah, I think you asked if you could be excused. Is Mr. Hendricks planning on appearing?
Yes, Your Honor.
Is he planning on appearing via Zoom or in person on that date?
Yes, Your Honor. He's
Which one? Zoom?
on another room. Zoom. Kimberly?
Okay, you're back in now. I've got you now.
He's in the other room. It's on, it's not Zoom. What's your other one? What are we on? He's asking for Mr. Hendricks.
No.
Is he on?
Yes. No, I see Mr. Hendricks. No, my question is.
Do you want to do it in Zoom or by person?
Oh, Zoom. I'm sorry. I didn't understand the court. Yes, prefer to do it by Zoom if we can, Your Honor.
All right, court will allow your client to appear via Zoom for docket call on September 15th. All right, thank you, Mr. Files.
Thank you, Your Honor.
Mr. Sanders, are you ready, Mr. Howell?
Yes, sir.
Mr. Howell, a plea today?
Well, Judge, it was set for a plea, and we had an offer from the state that initially we were in agreement with. And Judge, we've had a chance to talk about that several different occasions. Going over the paperwork today, Mr. Howell indicated that he did not wish to accept their plea offer. Judge, the offer, well, there's a couple of different options. Either he had the offer of 1 year of regular probation, 1 year probated for 1 year with a $1,000 fine, or 2 years of deferred with a $1,000 fine. There are a couple other options regarding the fine, but that really wasn't the issue. It was just a matter of pleading guilty to this charge, even though it's a lesser charge. We've had quite a bit of time talking about the case and the allegations against him by the alleged victim, and he's indicated that he does not wish to plead guilty even to the lesser included charge and wishes to have a jury trial.
And you believe that he has thoroughly considered his facts and circumstances of the case, and you believe that that's an informed decision?
Yes, sir, I believe it is. We had a chance to talk about, by pleading guilty to the lesser charge, that would not be any admission or confession of impeding breath, as the initial, as the indictment states. But regardless of that, even the allegation of causing any kind of bodily injury, he's not in agreement with that, with those allegations. In fact, I was even going to put him on the record real quickly about.
All right, Mr. Howell, raise your right hand and place on your oath. Mr. Howell, you are Denny Thurman Howell, is that correct? That's correct. Mr. Howell, do you swear that the testimony you give to the court today is the truth, the whole truth, and nothing but the truth, so help you God? I swear. All right, go ahead, Mr. Chamberlain.
Thank you. And Mr. Howell, just briefly, you understand that we were set today to come to court and enter a guilty plea to the lesser included charge of assault and family violence, which is a misdemeanor charge. Is that correct? That's correct. And you understood that the state's plea offer was either a year of regular probation or 2 years of deferred adjudication probation. Correct. And you understand that the state was reducing the charge from a third-degree felony, family violence, impeding breath allegation to a Class A misdemeanor, assault, family violence, causing bodily injury. And we had a chance to talk about the difference between those two allegations. And if your desire today to reject any plea offer from today as has been presented at this point and enter plea not guilty and have a jury trial set. You're asking the court to set this case for a jury trial. Yes, sir. And you understand too that we talked about the punishment range on a third-degree felony, and you understand what potentially could happen if you are found guilty, whether it's probation or you potentially have 10 years in prison. That's okay, Judge.
All right, the court is going to then set Mr. Howell for jury selection beginning October 26th. Mr. Howell, you're to report to the basement of the courthouse on that date. Your case will likely not be set or reached for trial. It'll be set for trial, but will not be reached for trial. You'll receive a notice of setting on that date with a new date. You'll continue to do that month to month until your case is reached for trial. Okay? Once you sign the notice of setting form, you'll be free to go. Shannon, is that all you have?
It is, Judge. I've been visiting with Mr. Skinner. I understand that he was here for arraignment today, so I told him I'd stick around. I haven't been retained yet on his case, but we have talked about potentially me representing him. So I was just going to let the court know that.
Let me review his case again. I believe this is the second time we've had a hearing like this. Mr. Skinner on commission to be charged with this. There's been in favor of arraignment filed on Matthew Kearns, 02130, represented by Matthew.
He's recording the cases 300.
Three yards from back to 02130. And then the reason I made it is that
Most of it was a trap.
so being able to diagnose the conviction. But we know it's in there. We do a very comfortable law. That it's set today, it's for arraignment. And that all of them are up here. Zoom. So here, I'm gonna put it here. Or you call it. Since he didn't get.
Mute, everybody's on mute, looks like.
I'm sorry, State, that you were not included on that, were you? Oh, and I'm sorry, you're muted as well. I'm sorry, I muted, didn't I? And I forgot to unmute. Let me tell you what I discussed with Mr. Green. Mr. Green had indicated that he and Mr. Cox had agreed to a bond reduction of 20,000. It was set at 100 based on the release of surety. And the court indicated that I would not be amenable to 20,000 based upon the fact that Ms. Red appeared in court and we administered a UA test that was never then brought to the court for a hearing on the confirmation. Mr. Green did confirm that the test was confirmed and that we addressed that at the last hearing. And I indicated to him that we did not address it, and he indicated that we discussed it. However, that was the day that Ms. Red did not appear in court and there was a hospitalization. My point to Mr. Green was that the court has not taken that matter up, and that had she not received the release of surety today, I would have likewise taken her into custody if there was evidence that of the confirmation, to which they were going to stipulate it here. So I told Mr. Green that I was willing to reduce it to 50 based on y'all's agreement, and that's because I believe that she's on her conditions of probation and on her conditions of pretrial release with her bail, and that she's tested positive for methamphetamine. And so at this point, what Mr. Green had elected to do, after being given the option, was that he's going to appear via Zoom today at 4 p.m. She's in custody, and she will appear at Greenton County Jail, and I'll let Mr. Green argue for a bail reduction lower than the 50 and give him a chance to present any of the mitigation evidence that he has regarding her medical, so that the court may not be aware of this afternoon at 4 at the conclusion of our regular jail docket. So we're just continuing this case until 4 o'clock. So apologize about that. I thought you had it in on there. Mr. Green was even talking and in the manner of Mr. Cox, agrees or doesn't, whatever, doesn't agree. So we didn't hear any response, and I didn't even check my volume status, so I apologize for that. This
You kept me from having to listen to Steve, so that's fine.
What's that?
I'm gonna apologize because you kept me from having to listen to Steve, so that's why.
All right, Mr. Skinner, you'll come to the podium. All right, Mr. Skinner, this is CR 20-65. Today we were set on your case for a status to hire an attorney. Court again reviewed your financials and finds that you do not meet the indigency eligibility for court-appointed counsel based on your finances. This is the second hearing, and you've not hired an attorney, is that correct? All right, now Mr. Sanders has indicated to me that you're in discussions with him, and because Mr. Sanders stuck around today to indicate that to the court, I'm going to give you one last reset. Okay, I'm going to reset you to September 15th, and whether you hire Mr. Sanders or someone else, I expect to have an attorney representing you on that date. You're charged with sexual assault of a child. It's 2 to 20. It's serious. Whether you're guilty of that or not, it's very serious. Okay? And this is not something you're going to represent yourself on. And you're going to, whatever ability you have to get money, you need to get that, and you need to hire an attorney. You need to be here with that attorney, or the attorney can file a waiver of arraignment on that day. So whatever you gotta do not come back into my court on the 15th and tell me that you need more time. This will be the third time. All right, this is our second setting today. I'm gonna give you one more. I'm giving you plenty of time. All right, and so you're at that juncture where you got to do what it takes to hire somebody. Okay.
Your Honor.
Yes.
I think Mr. Skinner and Mr. Sanders both need to know if they're going to enter into an attorney-client relationship. The Van Zandt County Grand Jury meets on Friday. The state plans on presenting a case to the grand jury on Mr. Skinner for failure to appear. So I just wanted both Mr. Sanders and Mr. Skinner to know that there may be a new indictment coming down on Friday, because that could have an impact on their agreement for representation. So I just wanted them to be aware of that.
All right, thank you, Mr. So I'm sure Mr. Sanders appreciates that, as does Mr. Skinner. So if you do not hire Mr. Sanders, then you'll need to provide that information to any other attorney that you hire that you're potentially looking at a new indictment for failure to appear. Another felony case, which would affect how much someone's going to charge you to represent you, because they're going to be representing you on more than one case, most likely is what the state's saying. Okay? So on September 15th, I'm going to give me a notice setting. I'm going to fill this out, have you back on September 15th with an attorney. All right, Mr. Skinner, I need you to sign here where it says defendant. I need your address. I need you to date it, and then we're going to give you a yellow copy. You need to see it. After you receive that, you're free to go. You just lay it up here on this one. All right. Thank you, Mr. Skinner. Appreciate it. All right, free to go, Mr. Skinner. September 15th with your lawyer. Sir. Mr. Ashmore, Ms. Dean. CR 19230, what say we?
We're gonna ask the court to report to the jail for the 130 docket and enter a plea bargain. The state of Texas is preparing the documents right now.
Yes, sir. All right, we'll see you at 1:30, Ms. Dean.
Thanks, Judge. May we excuse?
Yes, thank you, Ms. Ashmore. Yeah, I see that there was a waiver that was rejected, so no free trial date. What I was gonna do was ask them, I'm gonna ask you to reach out to them, to amend that free trial date. And I didn't wanna forfeit his mom when they tried to apply. He just throw it in there. I believe Mr. He's great right here. Long in the tooth, I think is what Hillary said. Hillary, isn't that what you say about older people? They're long in the tooth?
I don't know.